You're listening to the Valley Current.
Thinking about this question that you suggested to me, and we can record this, and of course I won't publish it without you seeing it, but I did actually grab that audio of that argument, and I thought I'd play a few minutes of it because I thought that argument was a really good example of what's happening in the patent office and why the older judges, like Judge Newman, are sort of like shaking their heads. So I'm going to play this for a second, if it'll play. Let's see if it does.
Sure.
Let's see if I got it to work. We'll see. I actually went and grabbed the recording, but let's see if it's going to turn on, because you never know if this stuff is done right until you play it for a while.
Whether if you work harder, you get paid more. Okay, Ms. Carsani, are you here?
And there's plenty of work for these judges to get all of the decisional units that they want.
That's really not the question that I'm trying to probe. Not that these are straightforward, honest APJs trying to do a job, but how you reconcile with a tradition of due process of law when an agency sets up a quasi-judicial structure, or Congress sets it up to essentially replace judicial proceedings, and in fact to provide estoppel in judicial proceedings to nonetheless adopt procedures which we know would not be available to the third branch of government. But let me ask you another question that I've been worrying about ever since the AIA was adopted, and that is that the statute says, and continues to say, that institution will be decided by the director, not by the tribunal. And early in the proceedings, as I understand it, that step was delegated by the director to the tribunal. And ever since then, we see here from there concerns that that is a distortion of the original plan, which seems to have been that the director, through the standard PTO examining corps, would take the first look at the case for which now review, say IPR, is being requested, and decide on some, I think the hearings use the term probable cause, decide whether there's probable cause to take another look. And the argument of the other side, I think the best argument, at least most forceful, is that to turn that threshold step, which was supposed to protect patentees because of the difference of the burden of proof and a lot of other things which happened on this review, that this first step is now delegated to the same tribunal that's supposed to objectively decide the merits, and that there is some sort of inherent bias, at least towards granting the institution request. And we all know that these are burdensome, extremely expensive proceedings that are, for whatever reason, imposed on patentees. And so that's a long return to my initial question, which is, how does the office justify that they have delegated the initial threshold institution step to the final decision maker?
So, Your Honor, this court rejected in Ethicon the argument that there is a problem with having the APJ decide both stages. And this court said this is just like a judge deciding both the preliminary injunction stage and the final merit stage. There are also a lot of incentives in this process to issue good decisions, right? Poor quality decisions are going to mean worse performance reviews. For the
You have a statute which is contrary to the way it's being implemented. You have a statute which says that the director will see to the initial institution stage, not the tribunal. And you're telling us, well, it's okay for the tribunal to do it because they're honest people. That's not my question. My question is the departure from the statute where, as according to the record of the 8 years of chewing over that went on in the legislative process, that this was an important aspect of the enactment.
Yes, Your Honor. So nothing in the statute bars the director from delegating these institution decisions, but this case isn't about the director's authority to delegate. We haven't briefed that question.
This question is about due process, and they make a very strong argument that they're not getting due process because of the incentives of the board, constituted board, to grant institution petitions. Explain to us why this requires the bonus. Here we have people operating at the maximum of the executive service and are paid a salary, and they make a large point, and particularly their amicus with it, with statistical support for the incentive to proceed to balance perhaps close cases in favor of institution. And they certainly do raise the question of having the same entity make the institution decision as do the adjudication. And you're saying that you're not prepared to respond to that?
I'm saying this court has already in Ethicon addressed the question of whether there's some kind of due process problem by having the APJs make the initial decision. And
you
the
have
court
nothing
said,
else to say beyond what was in Ethicon?
So I may not be understanding the question.
I'm trying to understand the difference. I think that there's a due process concern, particularly when it's in direct contravention of the act of Congress, in which the decision whether to take on a case, again, the decision of probable cause, and the final decision maker are the same when they were set up by statute to be different. That's my problem. That's my question.
So nothing in the statute prevents the director from delegating this.
But they're saying due process prevents the director. Of course, the director personally isn't going to read these petitions. We understand that. But there's an enormous core of experienced examiners, and it was contemplated that the examiners, I suppose more likely than not, certainly in the same art unit, so an examiner with a technological background, perhaps the examiner who examined it in the first place, would take a look and see if there's a question, a significant question, enough to pull this patent, which is issued, out of circulation essentially, and put it through this judicial process in the hands of experts. And this is where the delegating that operation to the same entity that conducts the trial and makes the final decision was explicitly avoided in the American Defense Act. And this is where I'm having trouble understanding how due process was as well served by the way it is handled now as the way it was intended to be set up.
So Ethicon tells us there's no due process problem. There are also through the performance review process, somebody who is issuing poor quality decisions is going to get...
I didn't ask about performance. I'm really trying to understand what I find to be the most troublesome issue, and one with due process implications, and is pressed particularly, again, by the amicus with statistical data.
So I would like to address that statistical data. It comes from an amicus brief asserting that patent holders are more likely to win cases that are instituted in October than in September. It's important to understand that that brief does not say. It does not say that more cases are instituted in 1 month or another. That's not true.
Okay, so you don't want to answer my question.
So that's sort of the back and forth that you kindly sent to me that I re-listened to, and that represents what now is so available online instantly. You don't have to go to the Federal Circuit's courtroom. Well, you go to their virtual courtroom,
right,
and listen to it live. And it's amazing that you can hear these live podcasts or broadcasts or internet casts, whatever you want to call them, radio casts, on their own channel, free, no charge, no hotel room, no flight, no nothing. You just listen in, and you can hear the tone of a jurist that I think is the oldest sitting federal, certainly the oldest sitting federal circuit judge, I'm pretty sure, maybe the oldest sitting federal judge altogether. And she's like 90, she's going to be like 93 next month. And I put up her bio because I just about fell off my chair when I realized she has a PhD in chemistry. I mean, she had a life before she joined the court, and she's been on the court. She was appointed by Reagan in 1984. I mean, it's such a rich story because you've essentially got this great grandmother. I don't know if she actually is a great grandmother, but you've got this woman who's really a super polished lawyer, law professor. She could be a professor of just about anything. And she's so capable, and she's dictating to, I think, the lawyer for the PTO, because there are actually 3 arguments, that, hey, you guys didn't get this right, and you got to fix it. And that lawyer's citing Ethicon, which I don't think is really on point when I kind of look back and remember Ethicon. But in general, what's your reaction as an IP lawyer to what's happened here? Because I could tell you what my reaction is, because you asked for my reaction, and I'll give it to you. I actually tweeted this. I said, we would never pay a jury a bonus for invalidating a patent as part of jury service. We would never pay a federal judge for invalidating a patent on summary judgment. We certainly wouldn't pay the Federal Circuit for affirming invalidations on some sort of bonus basis. So if you believe that any of those payments effectively corrupt due process, then why wouldn't you also believe that paying a administrative law judge, you know, the lawyer that turns into a contract judge, I like to say, they're actually very smart people. Why would you ever want to give them a financial incentive for essentially instituting an IPR proceeding, which is a new sort of approach for killing patents under the American Invents Act? And of course, there are a variety of views of whether IPRs are good things or bad things, but this financial incentive for institution is raising some real issues, at least for this jurist who's been on the bench now for, I guess, going on soon 40 years after having a life as a patent lawyer and as a chemist. So what's your thinking, Jill?
Well, I find this extremely interesting. First, going back to the oral argument, the attorney for the USPTO consistently dodges Judge Newman's questions. She keeps going back to, there is nothing unconstitutional about delegating. There is nothing unconstitutional about rewarding good work. She consistently avoids the actual issue, which is that they are basing salary decisions and bonus decisions on who is bringing in the most bucks to the USPTO. And that's what it really comes down to, because the administrative patent judges who are reviewed annually on a number of different factors. The primary factor is called decision units. And you get one decision unit for an ex parte appeal, for example, but you get 4 for an IPR, for an inter partes review. Now, one of the things that was brought up both in the Mobility Works appellate brief, as well as in there was another case that is co-pending before the federal court as well, New Vision Gaming and Development, which basically has the same issues. Did I lose you?
No, I'm here.
Okay, I don't see you at all.
Oh,
I must have.
Hold on. I'm here now.
Okay, no, it was my paper that hit it. The primary issue is that the USPTO is its own business and it lives off of its own funding. And most of the APJs get bonuses and salaries each year. They get performance reviews,
right,
which federal judges do not get. Federal judges are appointed and they do not have supervisors who say, yes, this is good, no, this is bad. APJs are responsible for meeting certain statistics. And one of those, although it's not brought out in specific language, but it's implied, is that they're going to feed the revenue of the USPTO. And what's interesting is when the attorney for the USPTO says, oh, there's plenty of work and they can do ex parte appeals, well, here are the fees. If you file a notice of appeal, the cost is $840. Now, if you file a request for instituting an inter partes review, it's $19,000.
Right.
And if it's accepted, then in order to start the actual trial, you have to pay another $22,500. So if the APJ is going to have a choice of whether he or she is going to take on an ex parte appeal or an IPR, it seems pretty obvious which one he or she is going to take, because they're going to get 4 decision units for the institution, 4 decision units for the actual trial itself, plus over $40,000 into the budget.
Right.
And
So,
that's going, and then you've got the subjective factors that the more senior APJs are looking at in terms of the performance review. And just as in any other business, these line judges, the line APJs, want to please their bosses. So it all comes down to if they want to please the customer. Who is the customer? Certainly not the patentee. The patentee doesn't want to bring an IPR. It's the petitioner who wants to bring the IPR. That's the customer.
right.
So they want to, they in order to bring in the money, they have to please the customer.
And it's become a bit of a big business because, the respondent in that appeal is United Patent, and United Patent essentially is a agglomeration of companies, or it's a company that supports an agglomeration of companies that effectively attack categories of what started as just troll patents, but now is actually gotten broader. It's a big business. I remember seeing the business plan for these guys. This was an interesting story. They came into my office.
Really?
Yeah, this was like about, I don't know, it was like maybe 5-10 years ago. Well, it wasn't 10 years ago because the statute just went into place 10 years ago. It was maybe about 7-8 years ago. They came in, they said, we have this idea for a company that is effectively going to be like a law firm, but it's not really a law firm, but we're going to hire a lot of lawyers. And we're going to essentially categorize what we think are patents that need to be killed. And I remember saying at the time of the business plan that I just don't think that kind of approach is going to work. And I remember thinking at the time, you really are maybe going to get into some antitrust issues about groups of larger companies that may agglomerate together and say, you know, we're essentially deciding that categories of validly issued patents, I mean, you have to jump a few hurdles, 101, 102, and 103 to get a patent issued, but then to go out and kill them in a way that's organized, you know, that may not pass muster, but, you know, no one to date, I think there's been a few attempts, but no one to date has tried to shut down that business, which essentially is like a marketing for defense lawyers, because the usual process now for litigation is a case will get stayed while an IPR goes into process. So really what we've done is we've kind of almost adopted the German view that, well, you can have like a separate validity trial, no jury. It's going to be decided essentially on this administrative process, which has been upheld, but this is now a new attack. Which is, it's a new attack. And the case, just for those listening in, the case is called Mobility Works versus United Patent. And United Patent, you can go to their website. I mean, they're very just fond of saying, we think we're doing a good thing because we fundamentally think there's a lot of bad patents, which is a different way of saying there's quality issues in the patent office that need to be fixed, but they can't be fixed at the first rung, which is when the first set of fees are paid. They have to be fixed later on when it turns out that someone's going to say, hey, that patent, if we don't kill it, or maybe that whole family of patents, if we don't kill them, it's going to be a big royalty hit on a lot of different companies if the litigation is successful. And typically these litigations are campaigns. So it's like an anti-campaign. You know, it reminds me of law school, a funny joke in law school, to go back with, like, in law school, you take a class in trusts in the morning and then you take a class in the afternoon in antitrust. And it's like this sort of like view that there's always a counter argument to everything, you know? Like,
well, of course, that's what makes lawyers.
Patent, right?
But, you know, that brings up to mind the fact that, you know, the USPTO is really getting pounded with these due process issues, because one of the cases right now in front of the, in front of the Supremes is United States versus Arthrex, which is whether the administrative patent judges are in fact unconstitutional.
Right. Which I think,
and that's going to be very interesting.
Yeah, my prediction on that is that probably you're going to see the Supreme Court say we need to just do this for pragmatic reasons. Like, in other words, you can almost argue that there's too many cases. You can almost argue that fundamentally federal judges like IPRs. If you talk to a random sample, you know, I think I once counted the number, and I think I said there's something like a total of 8,000 federal judges for all of the United States, all 50 states. That's really not that many federal judges really managing a ginormous federal docket. It may actually be only 6,000. It's no more than 8,000. When you hear them in random samples say, I love to hear that something's been delegated to somebody else. Man, if that happens, I don't have to actually dig into prior art and try to get the jury instructed correctly and deal with the battle of the experts. somebody else is going to deal with that problem, great.
But here you've got in Mobility Works, you've got the fact that Judge Newman almost, I would put money on the fact that case is going to come out that due process has been violated, and that the process that Mobility Works is claiming is definitely unconstitutional, and that will unquestionably will go to the Supreme Court. Now, I also think that the Supreme Court is not going to be very happy about overturning Judge Newman. So that is going to be very, very interesting as well.
Right. So when you think about this whole question of like, what if the Supreme Court is trying to also manage a federal system? I actually got this wrong. I thought it was more than this. I just looked on Wikipedia, and they say there are currently 870. I thought it was 8,000. I got this off by a factor of 10. 870 authorized Article 3 judgeships, 9 on the Supreme Court, 179 in the Court of Appeals, 673 for the District Court, and 9 on the Court of International Trade. That's a tiny number for the number of federal criminal cases, the number of federal civil cases. Now, how do you, if you're the Supreme Court and you're imagining the workload of 600, let's even call it 700, because there's a number of judges that are getting appointed now by the new president of the United States, and there's a number of vacancies. And of course, these folks get old, and unlike Judge Newman, they don't typically work into their 90s. In fact, I think they can take senior status at the age of 70, which is usually half the workload. And a lot of them certainly retire and go to work for jams with much higher compensation. But right. Generally speaking, think about that. 700 federal judges in the district courts and less than 200 in the courts of appeal. That's a tiny number. So when you say, I mean, it's a pragmatic issue for Chief Judge Roberts, who's got to run this place administratively. How do you deal with the argument that it's just impractical to imagine the federal judges not having this help? Because you could argue this is really helping the federal district courts clear out their federal patent cases. And I've been in front of a number of federal judges who just say up front, I need help. I don't have time for this. You've got criminal cases ahead of this ginormous patent case. It may be nice that you want a 3-week trial, but I don't have 3 weeks to give you. Go to arbitration. You guys can figure this out. It's a business case. Figure it out. I mean, seriously, it's a serious problem.
But then you've got 260 APJs,
right,
who they're lawyers, no question about it, right, but they are accountable to supervisors and to the supervisors who require them to be budget conscious, to bring in money, to perform up to certain standards. And there's a lot of subjective, criteria that goes into that. There is now the precedential committee. And from what I've seen now, I'm not a patent attorney, so I can't, say this is what I've seen on the patent side. But as a trademark attorney, what I have seen is there are required paragraphs for office actions.
Right.
And I can have 3 different trademarks that are absolutely not like each other and get the identical office action with the identical paragraphs, and they give you every single possible case cited. And it's sloppy and it's lazy, but it covers every single possible thing. And it's as if ahead of time, they decide that they're not going to grant the trademark. So they give you every single argument that is possible, but they don't write the arguments themselves.
No, it's a check the box automation. They just check boxes.
Exactly.
Right? It's like,
exactly.
It isn't the old school way of dictating up an opinion. They just check a bunch of boxes and you get kind of a compilation of every different argument that they want you to maneuver around. And if you're lucky enough to actually do that, you'll get the trademark passed to publication, and then you'll deal with an opposer if an opposer.
Exactly. And it's this, and my point is that the same director of the patent and trademark office is supervising the trademark office as well as the patent office.
Right.
And if this is what's going on in the trademark office, who's to say that this isn't going on in the patent office?
Oh, absolutely, it's going on. Everything is very analogous. People don't realize that there is a manual of trademark examining procedures. That's like, 600, 700, 800 pages, that manual. There's also a manual of patent examining procedures that probably is 2 or 3 times the length. It's all available online. You can get it for free. If you really want to study for the patent bar, you can just study that manual.
No, thank you.
Yeah, if you really want to study, I guess, to get really good at trademark office practice, you could study that trademark examining manual. But what they did is they derived out of those manuals a quasi-artificial intelligence statement that's not a system, that's not totally automated. It's like check the box. It's a little bit like, if I can get you on descriptiveness, I'll check the box about descriptiveness. If I can get you on genericness, I can check that box too. I can just keep checking boxes. And it puts a lot of work on you as the attorney prosecuting the trademark application or the patent application to actually deal with all of the stuff that's been rapid fire put into that office action. And if you do make a record that's convincing, you'll get to the next step. But if you don't, then you essentially have to go through some other process to try to get some review. But usually that's an impossibility, right? Once
Right.
It's pretty hard to imagine some sort of real appellate review on the discretion that happens in the examiners. But I always thought the examiners were biased to issue patents and to issue trademarks. That's what I always thought. I always thought there was a certain bias that they got more points, because if you're talking about incentive systems, look at the whole incentive system, because one of the things I thought about as Newman was making really good points there is, well, there's kind of a system with examiners to kind of move in the direction of getting more work through the patent office. And they get points too, because the little dirty secret here is there is no office anymore. Everyone's working a virtual, there is no showing up in an office and actually having someone as your mentor doing quality management. It's all virtual and it's all measured based on statistics. So they give points to try to incentivize certain behaviors. And there's points that are given to do this, to do that, to do the other thing. And you might have to look at the whole system, because maybe the problem with the quality is they're giving too many points to examiners to issue bad patents, or to issue patents that really should get more thoroughly examined. I mean, that's the question. Is there too many junk patents? Because if you talk to the people from that company that I mentioned, United Patent, they'll tell you they think that a lot of patents are junk, and they think that it costs a lot of money to kind of clean up the system, and that it's a good thing to do this, because if the patent can pass a second level of review, then maybe it becomes a good patent and it becomes stronger and becomes like more this, sort of more valid or more sort of robust, if you want to call it that, right?
Yes, but one of the things that concerns me in going through the briefs from Ability Works and listening to the non-answers to Judge Newman's questions, are the are the APJs actually qualified to do what they are tasked with doing?
Well, I don't know. I mean, there certainly was a view of Newman that maybe the better approach is to go with the expert in the art unit, because an APJ tends to be sort of like a generalist. He or she might be a patent lawyer. I mean, I know a few that retired out of different firms, you know, when that firm in San Francisco folded in the Ferry House. What was the name of the firm that?
Carol worked there, didn't she?
Limbach and Sutton.
Limbach and Sutton.
Right,
yeah.
right. Carol worked there. Yeah, exactly. And they had this distinctive letterhead with the Ferry building. The Ferry building got renovated and they wanted to raise the rent like 10x. And the lawyers were like, we can't afford, I mean, we can't move, we can't afford. I mean, they didn't go virtual. They just basically all retired. And some of the retired lawyers became APJs. And they tell me that there's art that they have not the foggiest idea about. And, you know, they're generalists. They've done a variety of patents. I mean, they might have certain specializations in certain areas, but when you look at the art units, I think that's Newman's point, that it may not be that you're getting the best talent, and therefore you might be getting talent that just wants to invalidate as a way to sort of deal with this, as opposed to finding sort of the fine nuance of whether there's some little incremental invention there. Because a little bit like, you know, how many different, you know, cell phones are they? And they all seem to get patented in one way or another, but to me, they all look the same. They all operate the same, but they all do it in different ways. And you might say it's a crowded field with a lot of patents, maybe a lot of thin patents, not really pioneering patents, but it takes a trained eye to figure that out. Sort of like different snowflakes, you know, they all have slightly different shapes, but they're still just water that's been frozen, right?
One of the things that I found interesting is I looked at the USPTO's fiscal year 2020 performance and accountability report. Now, there's a really interesting report. Apparently, they are going heavy on the artificial intelligence systems. And so, you know, this goes back to my question about, you know, the automated responses for office actions, and whether the APJs actually are now going to be more involved with AI and getting systematic reports so that they end up all moving in lockstep the way that the trademark examiners now seem to be doing.
Right. No, look, what's going on is there's the price of storage and the price of generating words and storing them on computers has fallen to such an inexpensive price that there's really no stopping the volume of information that's getting filed. I mean, today in the hearing, a judge said, you know, it's so refreshing to get, it was my letter, of course, I was so proud of it. I got it down to one page. The judge said, it's so refreshing to get a one-page letter that just is so clear and so beautiful. And it's just one page. And then the people on the other side give me something with like 500 pages. Mr. Russo wrote one page. Couldn't you make 2 pages? I'd let you know. I mean, literally, I was thinking to myself, this is the problem. You know, what was that old saw? I didn't have time to write a short letter, because it does take more work. I mean, I remember when I was in law school reading some of these decisions from the Supreme Court that were 3 pages. And I thought, this is elegant. It's so beautiful. It just says so much and so little. And then as I got through law school over 3 years, it was like 30, 40 pages became routine. And I thought to myself, the computer industry is proliferating words more rapidly than we can even think about them. And you can't do this as a human anymore. You need some automated help, whether you call that Westlaw, whether you call that Lexis, or whether you call it machine learning. I mean, that's really where this seems to be going.
I have had, on a number of occasions, clients get furious about their bills because I was able to condense 10 hours worth of work into 3 pages to go to the opposing counsel, win their case for them.
You're charging me $5,000 a page. You're charging me $5,000 a page, and the right answer is it was worth twice the price. Are you kidding me?
Right, but I mean, they don't understand what goes into it, and they certainly don't understand that less is more.
Less is more. Yes, less is more. And, I think of that all the time. And I say to myself, there's always this strange struggle between, God, am I going to look like a slacker if I get this down to 1 page? Or is it going to just delight the judge because the point is made? And, there really is something to be said that brevity is the soul of wit. And if you really get it down to that,
you make the judge happy, but what about your client?
Right, but
your client then says, "What are you billing me $20,000 for 1 letter?"
Right, and remember, years and years ago, lawyers got paid by the word, and people thought they were verbose. And these complaints, I mean, the style of complaints where it was or agreements, convey, assign, transfer, quit claim, like every verb in the book.
Wherewithal.
Right, I mean, it's amazing. But when you think about this case, I think Judge Newman's, the oral argument more and more is such a great tool for young lawyers to see when judges take on, as Judge Newman did. And I think that lawyer was a little surprised, like, wow, she's really being ferocious, but she was being very fair. And I always thought, as I was listening, I thought, well, what would I do in those circumstances? And I would have probably said something like, Judge Newman, you're right. It's an imperfect system, but we're working on improving it. I'm representing the PTO now, so you got to say this.
Right.
We have to have a system like this. You're taking a view that the entire American Invents Act needs to be rewritten. It's only 10 years old. We're improving it daily. Give us a chance to improve it. Your remarks are duly noted. They'll go back into the office. We'll rejigger the system. But trust me, it's not going to help to throw these APJs out or to imagine that somehow there isn't really going to be delegation here because the director just doesn't have the time and the professionals in the art units don't have the time. And this is the way it's got to work. And you know what? At least that would be truthful. At least
but now I'm Judge Newman.
Yes.
And right now I'm ruling from the bench.
Yes.
And Mobility Works wins.
Right. And maybe that's the right answer because
there is no due process.
Right. I do think at the end of the day, Judge Newman does want this to get up to the Supreme Court. So she's going to take a view and we'll see what they do with it because I think Justice Roberts is very concerned about an overworked, overtaxed set of federal judges that are real. I mean, maybe there's 8,000 total people with all the clerks and secretaries they have. That's where I may have confused the 800 number. They may have like a 10-to-1 ratio of magistrates and special masters and, law clerks and secretaries. Because I think in the whole federal judicial system, there's about 8,000 to 10,000 workers. And there's about, as I noted, 800 judges. But they're really kind of thinking to themselves, there's too much work. And if we do something that really puts everything back in the lap of those federal judges, we're going to blow fuses in the federal system. And I think that's something that Justice Roberts has to be worried about because particularly in a day where it's fundamentally like one Zoom hearing after another, it can be very taxing. And I think we're going to lose a lot of federal judges who say, you know what, it would be easier to work for JAMS or ADR systems. Or
just go back to being, just go back to private practice.
Or go back to private practice even. But, a lot of them are like, who wants responsibility for clients? If you're a JAMS judge, You just get to hear cases you decide to take, and then you throw the file away. You don't have to worry about the client. There's a lot of that kind of thinking. But at the end of the day, Jill, let's give a plug to your new firm, because you've come out of retirement. I have to say, I want to applaud you. You're like the first lawyer I know that's come out of retirement during or at the end of the pandemic, and you've joined the new firm in Orlando, Florida. But what's the name of it?
Losey, L-O-S-E-Y, Losey, P-L-L-C.
Losey.law.
Losey.law.
Not Losey.com, but Losey.
No, Losey.law.
And you're
J. Riola at Losey.law.
Yeah, and you are the IP, head of IP there.
I'm the head of the IP department. Yes, I am.
So for any issue, not just in Florida, but really for any federal trademark issue, federal copyright issue, you got some patent lawyers there too, probably, right?
Patent.
And you're going to help them grow to be a big
secret,
firm.
Litigation, whatever. We've got the best of the best.
That's good. So I've got some cases for you. Probably I got to figure out how to get you as co-counsel or joint counsel on some of these cases. But your rates are really reasonable. I won't reveal them here. You told me them offline. They're like a fraction of the price in New York. And
of course, California.
Of course, California is headed to the New York rate. I mean, it's shocking to me where it's going, but it's the way it is because these businesses in California continue to do really well and the pricing continues to be high. So maybe Florida has a lot to be said for becoming a place where lawyers are because real estate's a lot less expensive. Cost of living is less expensive. The price of gas is less expensive. You got a lot of sunshine, so maybe you're putting some solar panels on your roof as well, right? You don't need to keep electricity. You didn't do that?
No, they'll be blown off.
Oh, they'd be blown off. That's right.
No, we have a generator. We're having an in-ground generator.
Did you get a gas generator or did you get a diesel generator?
No, gas.
Gas. Mean like natural gas, right?
Propane.
Yeah, propane gas. Well, anyway, I hope to visit you in Florida and head to the beach and see your place. When do you think your place will be done?
We're supposed to close in 2 weeks.
Congratulations and knock on wood, best of luck. There shouldn't be any hurricanes. And give Jim my regards and hug the dog for me and tell him I still want to hear the ending to that Porsche story that you last told about the Porsche that was in the garage and ended up having the muffler eaten by a family of rats, if I remember this correctly.
Jim, come over here and say hi to Dad.
This goes way back. Jim was telling me that brand new Porsche had its mufflers eaten. And I don't know if it went worse than that, Jim. Did it go worse than that? It
was all the electric cables in the.
But you got it all replaced, right?
Oh, he sold the Porsche.
Okay. What is he driving now? Because he's such a car.
Oh, we've got it. It's what is it? An XFR. Oh, it's an FX. It's a FXR. It's a Jaguar XFR.
Oh, is that the SUV?
No. It's the Speed Demon.
Oh, the Speed Demon. Okay. Well, Jim, lots of luck with that. Lots of luck with the new house. I will look forward to visiting you sometime, but I don't know.
Oh, please do.
Because
please do.
Yeah,
we have to stay in touch, Jack. I miss you. I really do.
Well, what we'll do is we'll do a podcast at least every quarter, if not every month, because there's so many good, interesting decisions, and you do bring, like I do, 40 plus years of experience at the table, and you've seen a lot of issues, as have I. So bantering them back and forth is really worth something. I'll send you this recording, and you tell me what Losey thinks about it, and we can go from there. Okay.
Sounds like a great idea.
Talk to you later. Bye-bye.
Bye.
Bye.
Tune in next time on The Valley Current.